New York City Department of Education is refusing to provide certified and delegated documents in family court that will confirm and validate what they told me took place with my child's educational records. Allow me to explain. Back in March 1st, 2016, my child was transferred to Public School 83 in District 4. Before his transfer to Public School 83, his teacher had informed me that she was concerned that my child may have ADD. In addressing her concerns, I chose to get my son evaluated for special education, but I waited upon his transfer to Public School 83 in District 4, which he transferred there through a safety transfer. Upon the completion of the evaluation at the eligibility meeting, I received a classification of speech and language impairment. Immediately after receiving the classification, I informed the special education staff of Public School 83 that I was in disagreement with the classification. As I stated before, in addressing the teacher's concerns, I agreed for my child to get evaluated, but never did I think nor was I concerned about speech being an issue for my child. The only concern that I addressed was in relation to the fact that I did see that he did get distracted easily. Immediately, I provided the special education staff with a 2-page detailed letter. In this 2-page detailed letter, I informed them of, the reasons why I do not agree with the classification of being speech impairment. In the letter, as you can see here, this is just the first page. I basically provided this letter after the eligibility meeting, but I typed it the day of the eligibility meeting, dated for June 23rd, 2016. In the letter, I specifically stated that due to biases and improper handling and processing procedures and personal concerns of the administered evaluation, I did not agree with the speech impairment classification. I was told at the eligibility meeting that due to my concerns and my contention that the special education case would be closed. I continue on believing that the special education case was closed, since I once again disagree with the classification at the eligibility meeting. Okay, now I requested to receive sort of like a physical copy of the case closing, because all I had before was just the staff telling me that it was closed. The first letter I received confirming the case closing was given to me on June 20th, 2017, and as you can see, it says case closing, confirming that the case was closed on June 27th, 2016. Okay, on the top corner here, you can see the principal's name. The principal for Public School 83 is Frances Castillo, as she was logged into CPS at the time that she printed this case closing letter. I went further and I requested to receive my child's educational records. And receiving the educational records, I initially, when I provided the letter, to request his educational records, I gave it to the principal and to the CSE office, which is basically the Committee for Special Education. I requested the records. This is just basically a chart of the list of records that were provided to me and were included in my child's educational file. This is basically another chart that was also included with the educational documents. I requested the records for August 1st, as is dated here, August 1st, 2017, and I provided the letter through certified mailed to the CSE office, and the documents were given to me July 27th, 2017. And as you can see, this is the principal's name, Frances Castillo, and the assistant principal's name, Jesus Cruz. In the educational file, I found some documents that I have not seen before, did not see before, pertaining to the special education from June 2016. One of the things that I did see in the educational file was my child's IEP. I had never received the IEP, which I found it sort of odd, but I also found in the educational file a second case closing letter. Okay, this is also, once again, a case closing letter. I requested his records on June 23rd, 2017, and it's confirming that the case was closed on June 27th, 2016. Okay, as you know, children attend school from September into June. So today is December 11th, 2018. This school year begins September 2018 and will end in June 2019. Just in the same way that the following school year would start September 2019 and will end in June 2020. So when it's indicating that my son's special education case was closed on June 27, 2016, that basically means that the case was closed during the 2015-2016 school year. As time progressed, I believe that the case was closed. I received documents confirming the case was closed. I spoke to the principal confirming that the case was closed. But in addressing the documents that I found in relation to what I requested versus what I received in the educational file, I provided the principal with a second letter upon the starting of the school year after receiving the educational records. Once again, in July 27th, 2017, I provided this letter to the principal dated for September 15, 2017, and in the letter, I'm basically addressing the documents that I received in the educational files. And one of the things that I note in this letter for September 15 is basically stating, I was surprised to find his initial IEP report in his education file because, as I mentioned to you before and again over the phone on July 28th, I have never received his IEP until July 27 of the present year when I met with Mrs. Selena Melendez. Mrs. Selena Melendez is the parent coordinator of Public School 83. Okay, now, and speaking with the principal, because I did call her on July 27th, 2017, and on July 28th, 2017, I apologize, addressing the records that I received in the educational files, and in telling her about the IEP, she assured me that I had nothing to worry about, that basically, I received a second case closing and the case was closed. Okay, now in continuing the school, I basically move on believing that my son's special education case had been closed. Things were going on at Public School 83, such as bullying, that made me extremely concerned. So basically, I chose to, and I requested for my child to be transferred because things had took an extremely ugly turn where my child was getting bullied at school, and I wasn't receiving any remedy on, in terms of having that addressed. So my child was transferred into Public School 155, which is also in District 4. And to my surprise, when I spoke to met with the school psychologist, because once again my child was still having issues with from the previous school from being bullied, and he was sort of having symptoms of the results from the bullying. So in speaking to the school psychologist, he basically informed me that my child was on special education, and that there is at the time there is an active IEP in his educational file. I was completely shocked. I was completely shocked because I had received educational records, basically letting me know that my son's special education case was closed during the 2015-2016 school year, closed on, once again, June 27th, 2016. So how is it possible that, he would have an active special education case? When I was told that's not the case at all. In learning that my child had an active special education case from the school psychologist at PS 155 on January 3rd, 2018, I knew that, something sinister had happened because basically I basically was violated because it doesn't make sense that I can be given misinformation. This is a book that relates to special education law and learning some special education law because I was completely clueless in terms of special education and the law process. I basically had to file a due process hearing, and basically contending and basically disputing what had occurred with my son's educational file. And before, my son's IEP was placed and officiated in his educational file, I was never informed of this. And in fact, at the due process hearing, I have requested 3 subpoenas, and this is basically one of the subpoenas here. I've requested documents from the special education administrator, Nicholas Chavaria, and there I requested also documents from the principal, Francis Castillo. Okay, and I requested 2 witnesses from the DOE, which the 2 witnesses was Principal Francis Castillo and Assistant Principal Jesus Cruz. I requested documents. Basically, the documents that I requested is relating once again to the special education law, was documents pursuant to outreach, because before a child's initial IEP is officiated, the DOE has to basically consent. They have to seek parental consent, okay? And the law pursuant to outreach, to special education outreach, is pursuant to 34 CFR 300.322D. And I only know what I know now in terms of the special education correct process and the special education law is because I had to educate myself on the law, and the outreach law has to do with the DOE requesting detailed records of any and all outreach to involve parents in placement decisions, request consent for services, provide parent with the IEP, and all prior written notices. So the prior written notices is basically requesting consent from the parent before the IEP is officiated and placed in a child's educational record. And at the due process hearing, the DOE did not provide any outreach documents validating or showing that they requested my consent before placing the initial IEP in my child's educational file and officiating it, and then telling me that it was closed, but yet it was not. And these violations that occurred with my child's educational records led to me having basically and several ACS allegations on me. Okay, now based on ACS, now as I stated before, that due to the fact that I was told that my son's special education case was closed on June 27th, 2016, during the 2015-2016 school year, what ACS is saying, because I requested to receive a copy of any and all of the allegations that are being used against me. This was printed from ACS on June 20th, 2018. And based on this, as it has my information, okay, so based on this, what ACS believe is this, that during the 2016-2017 school year, child had an IEP. Child's special education case was closed last year due to parental refusal to consent to recommended special educational services. His disability classification was speech or language impairment. This is the thing. ACS does not believe that the case was ever closed. The special education case was ever closed. And this is obvious by the fact that they're saying that during the 2016-2017 school year, child was receiving services and that child did have an IEP. Yet, I'm being told and provided with documents from the New York City Department of Education indicating that my child's special education case was closed during the 2015-2016 school year on June 27, 2016. And I emphasize on this date is because there is obviously a severe violation and negligence that happened with basically within my child's educational records. At the due process hearing, okay, I received the CPS event log and the educational records, which is labeled as exhibits, which means this is for the due process hearing. This is page, I have 3 pages of the 15 of the CPS event log. This is DOE Exhibit 7-4, DOE Exhibit 7-5, and DOE Exhibit 7-6. And DOE Exhibit 7-4 is basically saying parents did not accept the recommendation on June 27, 2016, and letter was faxed under consent in error. CPS did not then accept the closure. So what was supposed to happen the moment I provided that letter at the after the initial eligibility meeting was that the case was supposed to be closed as was expressed to me. That did not happen. Another second page of the CPS event log, okay, which is basically page 7-6, is stating here, unfortunately, parents' 2-page refusal of service letter that she wrote was faxed into the prior written notice section of CPS. CPS interpreted the faxing of her refusal letter in the PWN section as consenting for the services, even though she clearly wrote a letter to the contrary. What doesn't make sense to me is that the DOE CPS event log is basically confirming that there was a negligence with the educational records. They were supposed to close the special education case, and it was not closed, okay? And what that means is that there was a negligence that resulted in me having an ACS allegations. I have never, not one time in my life, had an ACS complaint and allegation against me. And the only time that I've ever had any ACS and allegations against me was due to what happened with my child's educational records. But the first ACS allegation against me was that I know of was filed and received on December 20th, 2017. So from December 20th, 2017 to February, I believe it's February 5th, 2018, there was 4 ACS allegations against me. And those 4 allegations against me were basically from DOE employees and staff. But for some reason, although the ceaseless event law confirms that there was an error that had severely taken place, the DOE is not, the New York City Department of Education is not providing certified and delegated documents in family court. And 97% of the witnesses that will be utilized against me is DOE employees. Okay? Now, if this does not speak of something much more sinister and utterly disgusting, I don't know what does. I'm being provided with records. I'm utilizing my parental rights based on the special education law, okay, which is state and federal laws. The case was supposed to be closed as was indicated to me, and it was not. Not only was the case not closed, but now I have ACS allegations. ACS allegations that are horrendous and untrue. And it's there's no fact to it. It's just basically and simply allegations. Okay? And now I'm sitting here dealing with the outcome of the violation, and they're refusing to provide documents that were confirmed what they told me happened and what should have happened, but yet they're not providing that in family court. And they, meaning the New York City Department of Education. I did inform the New York City Department of Education because I have written several letters to the New York City Department of Education. I have written several letters to the Board of Education, and I have written letters to the superintendent's office in regards to what had happened with the educational records and how that negligence led to me having ACS. I have not received any corrective measures as to how to alleviate this issue. This is like like an abomination, a clear injustice that no parent should have to deal with whatsoever. As I stated before, my child was bullied while in school, so much so that he became reluctant to attend school. He would cry every day because he feared being in school. It became so bad that my son was not receiving an equal access to education, nor was he receiving equal access to learning. I had to pull my child out of school because I was afraid that, I would have a dead son. Like, how often do we see and do we hear about kids being bullied in school? In fact, due to ACS, there is on the documents, because this is just one page of the documents. This contains a lot of documents that I received from ACS, and there is no report and no indication of bullying in the New York City Department of Education file. And like I said before, because I disagreed, because the only concern that I addressed was in relation to my child being distracted, in relation to the fact that his teacher was concerned that he may have ADD. Speech was never a concern nor an issue for me. So in receiving that classification, I did provide the school with a letter. Once again, June 23rd, 2016. Okay? And if you go into the U.S. Department of Education website, you will see how disastrous and how, emotional and psychologically affects, how bullying affects children. Not only that, back in December of 2017, I did receive a diagnosis from my psychiatrist for psychological bullying. My son did receive that diagnosis. So how is it possible that there's no records and in a DOE file that speaks of bullying in my child's file? Which is mean that it was not investigated. And my son speaks. He speaks clearly. He reads clearly. He talks clearly. Okay? He does. He talks clearly. He speaks. Because basically, I just don't understand what is going on, and it's just so sinister that it just I can't I can't stop to imagine that. Is it possible that my son and I are being targeted? Like, is that possible? Because just the fact, just looking back at everything that took place within these past 2 years, 2.5 years since the classification and since being informed that the case had been closed and it wasn't, a lot has happened in these past 2 years. And the fact that the DOE is not providing records to family court, once again, confirming what they told me, because these records, providing these certified and delegated records in family court, would basically clear out what ACS believes happened versus what I was told happened with my child's educational records. And I was told they were closed during the 2015-2016 school year. And ACS believes that my child was provided with services during the 2016-2017 school year. And I did nothing wrong. Nothing wrong. And due to these violations, I have to basically defend myself against them. I mean, I am at basically trying to defend myself when 97% of the witnesses being used against me in family court are coming from the DOE. This is just sick. And I'm basically hoping that, asking for a donation so I can basically hire a family law attorney that would dispute and fight these vicious allegations against me, because that's all they are allegations. And it doesn't make sense that these documents are not being provided in family court. Like, it just doesn't make sense at all. It doesn't. How can you tell me something and then not validate and not confirm what you said happened? Like, it just doesn't make sense. So once again, in hoping and trying to find a family law attorney, I'm asking for any and all donations possible that I can be able to defend myself against these horrendous allegations. And I will hope that no one would ever have to go through this. And I will hope that, documents that should be provided would be provided, that would sort of dissolve and vindicate someone who is being falsely accused.